The former judge of the High Court and the Court of Appeal had a tough time explaining his past, with the commissioners keen to know some of his past decisions and whether he had any regrets. Top on the agenda of the JSC was his role as the chairman of a committee of the judiciary in 2003, which was gathering evidence on corrupt judicial officers. His report led to what became known as the radical surgery, where judges and magistrates who were deemed to be corrupt were hounded out of office. Ringera was accused of not giving those who faced the allegations a chance to respond to accusations leveled against them.
All of them had an opportunity to challenge these allegations. 6 of them opted to challenge these allegations. 3 of them did it successfully. 2 of them did not succeed. 1 of them had the charges withdrawn unconstitutionally, if you ask me.
What happened to the rules of natural justice?
They are applied, or ought to be applied, by any judicial or quasi-judicial body charged with taking action. In our case, the committee was not a judicial or quasi-judicial body. It was not charged with taking action. It was charged with gathering information and forwarding that information.
Ringera was pushed to answer why he had recommended that the judges be prosecuted or resign, yet he had not recommended that they be given a chance to respond. Worse still, the names of the judges would later be leaked to the press, and he says he did not have a hand in that.
I feel no remorse whatsoever except the adverse publication of names.
Did you release the report?
No.
So Judge Gisher released it?
I cannot so conclude.
Do you think it was foreseeable as you are gathering, you are investigating and listing down the names, that those names of persons who had not been given a hearing were likely to leak? Do you think it was foreseeable? And if it was, then would we also be talking about, with due respect, recklessness on your part?
If I were to do the job today, I'll do it completely differently in the new legal and constitutional environment.
He now serves in the Court of Appeal of the East African Court of Justice, an appointment that was made by the President. The JSC was concerned that he has been a big beneficiary of public appointments through the successive regimes, as a judge, as a Solicitor General, and twice as the chairman of the anti-corruption body.
You've had some way with the government. Is that true?
I wouldn't say I had a way with the government. I can say the government had identified me as a good, resourceful person to serve in legal capacities.
This doubling with the executive every so often, is it something that is good for this institution?
I'm absolutely committed to the rule of law. Fidelity to the Constitution and the law is my highest value. The independence of the judiciary, I treasure, I would protect it.
Another historical item that seemed to haunt Ringera was his decision to sue the Law Society of Kenya in 1991 over its engagement in politics and human rights activism. Ringera says that although he regrets the action, he had believed he was acting in the best interest of the society, which he claimed was in danger of being banned by the government.
We were used for political purposes to put bricks or a halt on democratic development.
He was also asked why he resigned from a law firm famous for defending human rights and reforms, where he, Kiraitu Murungi, and Gibson Kamau Kuria were partners, and then he joined another firm. He claims this departure was not because he was not a defender of human rights, but rather for financial reasons. Ringera says that if he becomes the Chief Justice, he will improve efficiency and speed of justice in the judiciary and infuse technology in the justice system. While the reasons for not including him in the earlier schedule were never made public, Justice Aaron Ringera becomes the first substantive applicant who had not been shortlisted to be interviewed. The rest will continue during the week. Andrew Ochieng, NTV.